Hello and welcome to another episode. You'll notice I have on the same shirt because I didn't feel like changing. of Legally Reagan here, or Legally Marek. Eventually, we're going to finally pick the name of what we're really going to be. So let me just take a moment here and share my screen. And we are going to start a series called Questions Lay People Ask. So I am currently a layperson, and this is the question that I had. And so I'm going to talk about one of the things that I believe is to have educated representation. And that means that not only your legal counsel has to be educated, but you have to. So the art of asking the right questions is very important. And so sometimes you will visit a legal professional or a medical professional, what have you, and you get the information that they provide, but it's very good for you to do your own research so that you can make sure that you ask the right questions. So people are very busy, they have a lot of time, but you want to make sure that you have the best outcome, and part of that depends on you. So questions lay people ask. Today we're going to talk about dissolving a nonprofit. So where did this come from? So we're going to talk specifically, we're going to use an example here, the state of South Dakota. So a woman is married and her husband dies. Her husband has a church that he is not functioning, but he is established as a nonprofit. The woman is I believe the secretary and the treasurer of the church, even though on paper she really wasn't involved. And then there's another man who's the vice president, and her now deceased husband was the president. Okay, so that's the setup of the situation. So now he passed away unexpectedly, and we'll do another video about probate in particular and when you need it and when you don't. But now we have this church that is held in a nonprofit corporation. So to make matters a little bit stickier, the church was administratively dissolved. So a few years back, I think 2018, it was administratively dissolved because the last time that paperwork was filed for this particular corporation was 2016. So the state of South Dakota administratively dissolved it. So we called the state, the Secretary of State, just to find out what we need to do. And even though it's been administratively dissolved, you need to pay $5 and submit the proper forms for it to actually be dissolved. So this isn't really an issue as long as, you know, that's kind of the only thing you have to worry about if it doesn't have assets, right? You just need to take the paper to get, you know, satisfy your paper needs and kind of move on. The issue in this situation is that there is a piece of property, a building that is owned by the church, and her husband was paying the utilities and the maintenance on this building. So what do, right? You can't just really walk away from it because you have a civic obligation really to figure out what to do with this property. So we don't have the answers here. We are here to help you identify the questions that you need to ask to your legal representation. So one of the things that we do is we start with Google, and we talked about South Dakota law about dissolving a corporation. So what I really like to look for is stuff that actually came from the state. So here we actually have this nice little domestic nonprofit corporation, courtesy of South Dakota Secretary of State. So this is put in easier terms for us to understand. So this talks about a lot of different subjects, but one of the things is that it talks about is dissolution. So a corporation may be voluntarily dissolved by the board of directors, adopting a resolution to dissolve. If there are members entitled to vote, the dissolution may be adopted by a 2/3 vote. If there are no members or no members entitled to vote, the dissolution may be adopted upon receiving a majority vote of the directors in office. Articles of dissolution must be filed with the Secretary of State's office, accompanied by a $5 filing fee. So the South Dakota, you can do your own articles of dissolution, and they also have, I think we can find them here. They also have, let's see, they have templates, right? We want the official ones. All right, so here we go. Dissolution right here. So for a domestic business corporation, let's see if it's the same for a nonprofit. We go corporations. This is how she told me to do it. And then we want to go nonprofit corporation. And you can file by line. Amended articles of incorporation, articles of dissolution. All right, here we go. For a domestic nonprofit corporation. So this is the right one for. So you see, you put the name here, you put the business ID, you say that you had a meeting, who was present, okay, the number of members, were there members who are entitled to vote, if there were no members who are entitled to vote, and then you attach a copy of a plan of distribution, if any, as adopted by the corporation, or state that no plan was adopted, right? So you need a plan of distribution of whatever assets. So all remaining property and assets of the corporation have been transferred, conveyed, or distributed in accordance with the provisions of the South Dakota, I think this is codified law 4627. So here we have, what does the South Dakota law here say, right? And so one of the things you can do is you can look up the law, and even if you don't understand it, when you talk to a legal professional, you can say, can you interpret this for me? Or is there anywhere in the South Dakota state law that I should look, right? These are questions that are going to make you an educated representee. Is that the correct word? Person that's being represented, right? So help your legal counsel to understand the questions that you have, right? You want to make sure when you are in a situation that you are getting as many, that you're really having the best outcome, because there are more than one way to satisfy a situation. So that's what we have here, okay? So let's close this because we don't need this. This are the articles of dissolution. So we're gonna go now to this here, the codified laws here, 4726. And here we go. Right. So 4726. So procedure for dissolution, 4726.1. A corporation may dissolve or wind up its affairs in the manner provided by 47, Title 47, Section 26.2 to 4 inclusive, right? So this is what's going to tell us how we do our affairs. So now we're here. And I want to go, let me see if I can go backwards a little bit so I can see the whole list of everything here. I just want to go to chapter 26. Aha. And now we have a whole list of everything that is in Title 47, Chapter 26 about nonprofit corporations. So 26.1 is the procedure for dissolution. We just read this. So let's go to 26.2 and let's see what it is. So where there are members entitled to vote, the board of directors shall adopt a resolution recommending that the corporation be dissolved and directing that the question of such dissolution be submitted to a vote at a meeting of members entitled to vote, which may either be the annual or a special meeting. Written notice stating that the purpose or one of the purpose of such a meeting is to consider the advisability of dissolving the corporation shall be given to each member entitled to vote at such a meeting within the time and in the manner provided in chapters 4723 for giving notice of meeting of members. A resolution to dissolve the corporation shall be adopted upon receiving at least 2/3 of the votes entitled to be cast by members present or represented by proxy. So the question here is, what is a member, right? What is a member? So let's look that up here and see. What is a member of a South Dakota nonprofit? Let's just see what we get. What is a member? So we have members, And then we have directors. So that's the question that I would ask members. A nonprofit corporation may have one or more class of members or may have no members. If a corporation has one or more classes of members, the qualifications and rights of the members of each class shall be set forth in the articles of incorporation or the bylaws. So you have to go back to the bylaws, right? This particular situation, the husband had this before they even married. So the now widow has no idea what's in the bylaws or the articles of incorporation, so she needs to find them. If you don't have them in your house, did you have an attorney, a local attorney in this case? She did. Her husband had used the same attorney for years. Also, you need to go back to the state and see what they have on file for you, right? And so here you have it. So now my question is, when we talk a little bit about amended articles of incorporation may be amended by the board of directors adopting a resolution stating the amendment. If there are members entitled to vote, the amendment may be voted on at either a special or annual meeting. So the question is, if you don't have bylaws or articles of incorporation, and you and the other directors or members get together and make some new ones, right? So that you can move forward and change things for how the company is set forth, okay? So I don't know, but that is a question for your legal counsel, right? So actually here, let's start writing down our questions. So we're gonna get a new slide. So question. Question 1. And that's just, here we go. Okay. Here. What is a member? What is a voting member? Does my, maybe it should be topic 1 actually. All right. What is a director? Does my nonprofit corporation have members, voting members, or directors? Right? This is something you need to know because these are the people that can make decisions going forward, right? And you don't know the answer to that. So that's going to be the first topic. Okay, that's the first thing we need to do. Now, let's make a new slide. And we're going to say topic 2, articles of incorporation and bylaws. And I have bylaw. I need to add a S to that, okay? All right, so what if okay, does the secretary, what if I cannot, what should I do? What should I do if I cannot find the articles of incorporation and or bylaws? Does the Secretary of State have a copy of my articles of incorporation? No, I can keep it, or bylaws. Okay, that is the question we need to ask. Then we need to say, can I change, or okay, how do, if I cannot find my articles of incorporation or bylaws, can I adopt new ones? If I need adjustments to the articles of incorporation or bylaws to handle handle dissolution, and I change them to fit the current circumstances of the nonprofit. Okay, and then who has to agree with changing the articles of incorporation or bylaws? What if the people that need to agree are deceased, or okay, let's do this separate. What if the people that need to agree, what if the members and or directors, what if the other members are now deceased? What if I do not know how to contact the other members or directors? And then you have two different types of members. So what responsibility is owed to non-voting members? They need to be notified of the dissolution. So these are quite a few questions, right? And some of them overlap, but this is just to really help you to ask your attorney the type of questions that you need to ask to get the answers from reading this, right? These are the questions we have. I don't know the answers, right? But we can try our best to know the questions, right? So questions lay people ask. All right, so here we go, topics, articles of incorporation bylaws. Now let's go back here to the South Dakota Code here, and let's do this. Sorry, I'm always so many tabs open. Okay, so here we have, this is what you need to do for dissolution. Right? No. Let's go back. Okay, here we go. Procedure for dissolution. All right, we have that. We did that. Now, vote of members, we did that too. Okay, so we need to know where there are members entitled to vote. The board of directors shall adopt a resolution recommending that the corporation be dissolved and directing that the question of such dissolution be submitted to a vote. Okay. Where there are members entitled to vote. So I have a feeling that this means that if you don't have members that are entitled to vote, they don't have to be notified. Okay, so let's go to 3. Dissolution and liquidation. Dissolution by board of directors in a corporations without members entitled to vote. So here we go, we're answering our question. Where there are no members or no members entitled to vote, the dissolution of the corporation shall be authorized at a meeting of the board of directors upon the adoption of a resolution to dissolve by the vote of a majority of the directors in office, right? So in this question, what if one person is both the has two positions. Let's go here. Okay. I'm trying to pass forward. What are directors. The affairs of the corporation shall be managed by a board of directors, which shall not be less than 3 members. The number of directors shall be established in the bylaws, but the number of the initial board of directors must be stated in the articles of incorporation. So here we have another issue. What is the board of directors, right? So let's do topic 3. I believe that the board of directors who are the board of directors of a non-profit. I believe that they are who are the board of directors of a non. Classes of members, correct. Okay, let's see. Board of directors. All right, so except, sorry. In South Dakota, except as authorized by 472322, the affairs of a corporation shall be managed by board of directors. Directors need not be members of the corporation unless the articles of incorporation or bylaws so require. The articles of incorporation or bylaws may prescribe other qualifications for directors. Okay. If the articles of incorporation or bylaws so provide, the board of directors may designate one or more committees, each of will consist of one or more directors and such additional members as specified in the resolution, which such additional members need not be a director or member of the nonprofit corporation or resident of the state. Okay, no, this is too deep. So the question is, are the bylaws All right, so the number of directors of a corporation shall not be less than 3. Subject to this limitation, the number of directors shall be fixed by the bylaws, except as to the number of the first board, which number shall be fixed by the articles of incorporation. The number of directors may be increased or decreased from time to time by amendment to the bylaws, unless the articles of incorporation provide that a change in the number of directors shall be made only by amendment of the articles of incorporation. No decrease in number shall have the effect of shortening the term of any incumbent director. In the absence of a bylaw fixing the number of directors, the number shall be the same as stated in the articles of incorporation. Let's see, classes of directors. Directors may divide it into classes in terms of office. Each director shall hold office. So that's the thing. I don't know if, okay, corporate officers. Let's see. Yep. The offices of a corporation shall consist of a president, one or more vice presidents, a secretary, a treasurer, and other officers and assistant officers may be deemed necessary, each of whom shall be elected or appointed at such time and in such manner for such terms not exceeding 3 years as may be prescribed in the articles of incorporation or bylaws. In the absence of such provision, all offices shall be elected or appointed annually by the board of directors. If the bylaws so provide, any 2 or more offices may be held by the same person, except the offices of president and secretary. The articles of incorporation or the bylaws may provide that any 1 or more officers of the corporation shall be ex officio members of the board of directors. So let's see what ex officio means, because I don't know. Maybe you do, but I don't. So let's learn something today. Oh, as a result of one's status or position. Okay. Okay, so the articles of incorporation or the bylaws, they provide that any one or more officers of a corporation shall be ex officio because of their status or position, members of the board of directors. Okay, the officers of a corporation may be designated by such additional titles as may be provided in the articles of incorporation or the bylaws. Unless the articles of incorporation or the bylaws so prescribe, officers need not be directors. All right, so here's the thing. In this particular situation, we know who the officers are. The president is now deceased. It was the husband. The secretary and treasurer are the wife. And then there's another gentleman who's the vice president. So we need those articles of incorporation to see if the directors, because of their office, I think you pronounce it ex officio. Let's see if we can hear how it's pronounced. Ex officio, that's correct. So because of, and I'm sorry that we're looking at underwear here. Okay, so because of ex officio, the status of one's status or position, they become board directors, right? So the other issue is that if that is the case, now this administratively dissolved corporation actually only has 2 people, right? And the president and secretary can't be the same person. So that's a challenge because you have to have 3 for a nonprofit corporation. So I'm not sure how you fix that. So let's go here. Let's go back to questions. We need directors versus officers. Okay. We're talking about this specific situation, right? But what we need to know is, I'm sorry, let's move this over. And let's move this over. Okay. All right, so now what we're gonna do. So we wanna ask questions. So are the directors, okay, do my articles of incorporation state that the officers are ex officio or by status of their position as officers, also directors of the nonprofit. If the officers, okay, are also directors, how do we proceed when the president of the is now deceased, leaving only 2 officers? If the officer leaving only 2 directors, if the directors are also officers. That's a question we don't have. Okay. How does the fact that this nonprofit was administratively dissolved affect, how does the fact that this what does the fact that this nonprofit was dissolved mean for replacement does the let's see. Nonprofits are required to have 3 directors, and the office of president and secretary cannot be held by the same person. If the officers are also directors, how do we proceed when the president of the corporation is now deceased, leaving only 2 directors? If the directors are also officers, if the nonprofit is already administratively dissolved, as a new director needs to be selected, before nonprofit is, what do we call it? Officially, or is officially dissolved. I don't know what you call it, but it's administratively dissolved, but you still need to go back and actually dissolve it. All right, so directors versus officers. So this is really important because we don't know who the decision makers are, right? So like this, okay, we need to know who are the decision makers. That's our big issue. We don't know who the decision makers are. Okay. All right, there we go. Directors versus officers. All right, this is taking a little longer than I anticipated, but it's deep. All right, so let's go back to, let's get rid of this, 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 let's get rid of this. And let's get rid of this. Let's go back here. To section 4, resolution to dissolve. Resolution to dissolve or cessation of business affairs, notice of proposed dissolution to creditors, collection and distribution of assets. Upon the adoption of a resolution to dissolve by the members or by the board of directors, where there are no members or no members entitled to vote, the corporation shall cease to conduct its affairs except insofar as may be necessary to wind up. They shall immediately cause a notice of the proposed dissolution to be mailed to each known creditor of the corporation and shall proceed to collect its assets and apply to distribute them as provided in this chapter. All right, so now you have a resolution to dissolve. Let's see what we do next. So let's go to 5, manner of distribution of assets, particular assets, remaining assets. So manner of the distribution of assets, particular assets, remaining assets. The assets of a corporation in the process of dissolution shall be applied and distributed as follows. All liabilities and obligations of the corporation shall be paid and discharged, or adequate provision shall be made to do that. Assets held by the corporation upon condition requiring return, transfer, or conveyance, which condition occurs by reason of the dissolution, shall be returned, transferred, or conveyed in accordance with such requirements. So it's possible that some of the things were on loan or they were given to this corporation for as long as it was in existence. And so now they might have to be returned, transferred, or conveyed, right? And I believe that will be set forth in the bylaws or the articles of incorporation, right? So now here we get to the tricky part because this is a church. Assets received and held by the corporation subject to limitations permitting their use only for charitable, religious, eleemosynary, I think you pronounce this. Let's look it up again. Okay. Eleemosynary, relating to or dependent on charity, charitable. Eleemosynary. All right, so it's not a familiar word to me, but maybe it is to you. So let's go back here. So, okay, assets received and held by a corporation subject to limitations permitting their use only for charitable, religious, eleemosynary, benevolent, education, or similar purposes, but not held upon condition requiring return, transfer, or conveyance by reason of dissolution shall be transferred or conveyed to one or more domestic or foreign corporations, societies, or organizations engaged in substantial similar to those dissolving a corporation, pursuant to the plan of distribution adopted as provided in this chapter. So I'm going to copy with citation, and I'm going to put this here. Okay, I need a new slide. We want to put this here. All right. Topic 3, topic 4, distribution of assets. All right, so first of all, we just need to know crazy about this. There we go. So this is the law. So can the church be sold and the profits distributed to the directors? If, so now it says, so now I want to know, okay, so if the current articles of incorporation do not specify that the assets held by the corporation have a condition requiring return, transfer, or conveyance by reason of dissolution, can the articles of the corporation or bylaws be amended to allow the property to be sold and the assets to be sold. Okay. Can the article of bylaws be amended to require condition of returning assets to the director. So this is the question. So it seems like if you set it up from the beginning with a condition, then when you dissolve it, you can give it back to who gave it to you, right? However, if you did not do that, then what happens is you have to transfer the assets to one or more. You have to transfer it to basically an organization that's involved in similar activities. That's the law, right? the way that I understand it. Once again, ask your legal professional to make sure that you understand what's really going on. But my point is that if the bylaws and articles of incorporation don't allow that, can we amend them to put in a condition before we sell it? That would allow us to just sell the property. In this case, it's a physical church asset, and then distribute the profit among the director or the directors. So that becomes the question that we have. How are members involved in the sale of assets? If we were allowed to change the articles of incorporation, if we were allowed to change the articles of incorporation, the bylaws, with a condition to return assets, would the members have any rights to the assets? Okay, member. Okay, so yeah. Okay, so there we go. And let's just look back here again and see if we have any other thing. Okay, so other assets, if any, shall be distributed in accordance with the provisions of the Articles of Incorporation or the bylaws to the extent that the Articles of Incorporation or bylaws determine the distributive rights of members or any class or classes of members or provide for distribution to others. Any remaining assets may be distributed to such persons, societies, organizations, or domestic or foreign corporations, whether for-profit or nonprofit, as may be specified in the plan of distribution adopted as provided in this chapter. Okay, so you need a plan of distribution, and that's in the next thing. So here, other assets. Let's copy this one too. All right, let's make this white. And no, I'm sorry. Let's make this. Let's make this white. And no, let's make this white, and let's make this transparent. Sorry. Let's make this white. No, this transparent. Make this white. A little bigger if we can. Okay, so once again, this is the question that I actually need to, oh, sorry, move this question below to here. Right, so I want to know. All right, can we change it if we don't like what it says? Right, so these are the questions that we have. All right, there we go. These are the questions. So we want to know, can we change the bylaws or the articles of incorporation regarding distribution of assets? So lastly, let's talk about this. Let's talk about plan of Plan of, what do you call it? Plan of distribution. Let's talk about the plan of distribution. All right. Get rid of this. Weird. Let me move this over first. And then let's do this. And then let's move it up. Okay, so let's go to the next section and look at the plan of distribution 26.6. A plan providing for the distribution of assets not inconsistent with the provisions of chapter 4722 and 4728 inclusive may be adopted by a corporation in the process of dissolution and shall be adopted by a corporation for the purpose of authorizing any transfer or conveyance of assets for which this chapter requires a plan of distribution in the manner provided by 4726.7 and 4726.8. So let's see. Where there are members entitled to vote, the board of directors shall adopt a resolution recommending a plan of distribution and directing the submission to a vote at a meeting of members. Yes, so such plan shall be adopted upon receiving at least 2/3 of the vote. All right, so if we don't, where there are no members entitled to vote, a plan of distribution shall be adopted at a meeting of the board of directors upon receiving the vote of the majority of directors' office. Okay, so let's do this. How do we adopt plan of distribution? And we have to go back here again. Do we have members / voting members? Or can we adopt plan with the meeting of the board of directors? How if one of the board of directors, if the board only has 3 members and one of them is deceased, how is this managed? Keeping only 2 members. How can a majority be reached if there is dissension between the directors? I'm sorry. Using this word interchangeably. Okay, I can't use this. I made 2 members. I got to use directors. I made 3 members of the board. All right, so there we go. So it's codified law 47. And just let me also this too. It's also here that we need to look at this. Oh no. Okay, so this is a reference to nonprofits with members, right? And the other one. All right, so let me just go back here because in this one it talks about 4723. Power. Okay. So this is talking about going to court. Courts of equity shall have full power to liquidate the assets and affairs of a corporation in action by a member or director when it's made to appear that the directors are in a deadlock in the management of corporate affairs and that the irreparable injury to the corporation is being suffered or threatened by reason thereof, that the acts of the director, those in control are illegal, oppressive, fraudulent, that the members entitled to vote in election of directors are deadlocked in voting, that the corporate assets are being misapplied or wasted, that the corporation is unable to carry out its purposes. Okay. And let's look at, okay, so this is by a creditor, application by corporation. Courts of equity shall have full power to liquidate the assets in the present corporation upon application by a corporation to have its dissolution continue under the supervision of court. All right, so let's take these two. And we just want to know basically what they mean. All right. So can we have it dissolved in court? Do we need to go to court for it? We can ask about this one. And then let's go back to let's go to this part here. And this to be transparent, this to be white. Topic 6. And the court help us to do we need the help of the court? That's basically what we want to know. Do we need the help of the court? I have no idea. It seems like okay. So we need another one here because what is our goal? Sell the how can we sell the church held in a administratively dissolved non South Dakota administratively dissolved nonprofit corporation and distribute the proceeds to the widow of the Profit. That's what we want. How can we sell it and distribute the proceeds? How can we sell a church held in a South Dakota administrative dissolved nonprofit corporation and distribute the proceeds? How can we legally sell a church held in a South Dakota administratively dissolved nonprofit corporation and distribute the proceeds to the widow of the nonprofit's president? The proceeds to the secretary and treasurer widow is also the nonprofit's last annual filing of the nonprofit widow is listed as both the secretary and the treasurer of the nonprofit corporation. How can a church owned by a South Dakota and administratively okay, so now we get to the end and we get to our big question. So legal question. All right. How can a church owned by an administratively dissolved South Dakota nonprofit corporation be sold and the proceeds from the sale be legally distributed to whatever nonprofit's president? Is that proper English? How can a church owned by an administratively dissolved South Dakota nonprofit corporation be sold and the proceeds from the sale be legally distributed to the widow of the nonprofit's president? At the last annual filing of the nonprofit, the widow is listed as both the secretary and the treasurer of the nonprofit corporation. All right, so here we go. This is our questions lay people ask, first section, big, hairy legal question from the state of South Dakota. And here are other questions from the law that should be asked, that are good questions to ask your attorney. So overall, we want to understand South Dakota Title 47, chapter 26, right? So that's where all this is coming from. That's what we want to understand. Man. Hold on, let me fix this. No. This. And this. And this is where we want to focus our attention. To the South Dakota law. We need to understand this section of law. You also want to ask, is there any other section of law that you might be missing, that you might not know about, that the attorney wants to direct you to? So this is from your research, but they're the expert, so ask them. What other part of the law do I need to be concerned with? All right, so we have to go, but this is another episode. Thank you for joining us on Legally Nerette, Legally Raven-Haired, Questions Lay People Ask.